questions.
Members, any questions for the sponsor? Seeing none, we'll open public testimony. Chair calls Fred Wilshusen, and I probably butchered that name, and Scott Seamster.
Got it right.
Did I really? Oh, I'm starting off the day well. All right. Why don't would you like to go first?
I'm against, if that's good for the
That's as
committee.
good a place to start as any. If you'll just state your name, who you represent, whether you're testifying on, for, or against the bill, and testimony is limited to 2 minutes.
Thank you to the chair and committee members. My name is Fred Wilshusen, and I'm general counsel for the Texas Construction Association, testifying against. I call it HB 3306. What's the way that the current system works? And I don't agree that the person who's at fault is not responsible. Currently, subcontractors sign limited indemnity agreements, and that means that the sub is responsible for all damages that are the result of the sub's fault. Everybody else out on the construction project, like the owner, they're responsible for their own fault. That's a limited indemnity agreement. That's a fair allocation of risk. You're responsible for your own fault. It works. It hasn't been changed in the 14 years since it was adopted in 2011. What would happen if 3306 was adopted? With regard to the utilities, they could be 100% at fault, and the subcontractor who was not at fault would have to pay all the damages. This would become a contract of adhesion. I lived for 25 years with this system prior to 2011, and it would flow down to the subs with very little bargaining and very little negotiation. And every session here on out, some new industry would come into this legislature saying why an unfair allocation of risk is justice for their particular industry. I understand this was due to a bad jury verdict. There are other ways to deal with that. Have an arbitration clause, waive jury trials in your contract, change the way that new trial procedure, introduce new trial procedures, but don't adopt a risk allocation system that was replaced by the legislature 14 years ago and that constitutes a fair allocation of risk. This is the area I practice in. I'm happy to answer questions.
Thank you. We'll hold the questions for the full panel. Mr. Seamster.
Thank you. Good morning, Chairman Schwartner, Vice Chair King, and members of the committee. I'm for. My name is Scott Seamster, and I am the Associate General Counsel for Texas New Mexico Power. We're an electric utility serving 275,000 customers across Texas. We're the only non-contiguous transmission distribution utility in the state. I'm here today to support HB 3306, which would allow utilities, electric cooperatives, and municipal utilities to enter into arrangements where the contractor indemnifies fully the utility for that contractor's work. The situations contemplated by the amendments to 3306 are more simple engagements than the harm that was thought to be addressed in the original statute. Consolidated insurance programs are not the form of insurance that we do for our work. We're not building large buildings. We're putting up wires, poles, and substations. And just like a public work, that's for public infrastructure. When we get an injury to a third party, the plaintiff sues everybody. Under the current statute, I have to pay, and ultimately ratepayers pay, the cost of that, and I have to get a zero from a jury to get that. There's no arbitration clause between us and a plaintiff. And so this would allow us to have the contractor stand up. I'm dealing with sophisticated parties. They're already signing these broad form indemnities for all of our work. The level of insurance won't change because they're insuring for the full risk already. I thank you, and I'll take any questions.
Members, any questions? No one. Senator Campbell.
The first gentleman.
Fred.
So you were against the bill. You took notes as not Fred. Scott was giving his testimony. You took notes. What did you find in his testimony that seemed to be bothersome? I mean, obviously he's for it and you're against it.
I spent 25 years with this system before, after
Right.
20 years of trying to change it, we got a fair allocation. People should be responsible for their own fault. And what they would have happen would be if you could remotely, indirectly connect the subcontractor to whatever injury took place, then the sub has to pay 100% of the damages, even if they are 0% at fault.
Okay.
That's a broad form indemnity. So, many states prohibit these.
Okay.
And Texas has since 2011. That's what I object to. And like I say, I had to live with it for 25 years.
Thank you, Fred.
Thank you.
And your response to that one, just real quick.
I'm dealing with sophisticated parties that already signed these in multiple states. They know how to put that in their business model. I'm not taking advantage of small contractors and small town. I'm dealing with sophisticated parties.
Thank you. Thank you both. Thank you, Mr. Chairman.
Okay, I'm a little bit confused. So first off, what industries would this apply to, or would it apply across the board to all construction?
Just electrical,
Just
Yeah,
electrical.
transmission.
All right.
is
So
what
let's
I
say you've
understand.
got a project going on, y'all are refitting high lines or whatever, and you've got a subcontractor, and that's both of you this. And so you've got, let's say, I'll just say Encore, so it's not you. So say Encore's the project manager, or it's their project. They've got numerous subs out there. Let's say you've got subs that are clearing out the right of way, and they probably have a master services agreement with you, I'm assuming, and so under and let's say that they damage the farmer's barn when they're clearing it out. They start a fire and it burns down the barn or something like that. So the farmer sues Encore and everybody else, and that sub. And so under current law, explain to me, both of you, what would happen with regard, and then what would be the difference if this bill passed?
Certainly. I would do the thing.
Start off. Yeah.
Encore would tender the indemnity under the limited indemnity agreement to the general contractor, the sophisticated party they're talking about. Well, what would they do? They'd turn around to the subcontractors and tender it to them. And so the subs would end up having to defend that. And to the extent that the sub was completely at fault, they'd be responsible. And it's not just their insurance. They're personally responsible. It's not limited to your insurance coverage.
Now, what
So-
would happen with what would the legislation change?
Well, what the legislation would change would be, let's say it's 100% the owner's fault, which is very possible, or 100% some subcontractor's fault that the general did not tender that to. Under this legislation, the sub would absolutely have to go in and defend something they might have a remote or no connection with whatsoever. That's not what happens today.
I disagree with the alignment. We don't use a master contractor and a bunch of subs. I hire for the vegetation management. I hire one guy. He's going to clear that line. He causes the fire. When the plaintiff sues, he sues everybody. And I say I want to tender, and the insurance company says, well, we're not going to pay for your indemnity because the plaintiff has just said you're negligent. As soon as the plaintiff says I'm negligent, I don't get any coverage until I go through the trial and a jury says zero liability on the verdict. At that point, I've already had to spend a bunch of money. And I've gone through this several times already where we're at a point in having to decide, do we want to keep spending money or do we try to have to then pay up and settle? In effect, I've had the very thing with the VM contractor. I feel like I'm paying for that VM contractor's negligence if I'm settling out because I don't want to stay on the litigation ticket ride. This is the difference with this would be that I would negotiate with that party and say, look, I'm hiring you to do all this VM. You stand up to it irrespective of what the plaintiff says. And therefore, I'm able to handle liability that ultimately those costs would then flow back to customers and keep things consistent and what I can see, what I can plan for in getting our costs down and the liability I'm going to have to pass on to customers. So the difference of this would be, I would agree, and they sign these indemnities already. The levels of insurance aren't going to change because they're insuring for their full exposure anyway.
One brief clarification. In 2011, any injury to your own employees was exempted. So you can give a broad form indemnity for any of your own employees. So if it's just one contractor who's getting injured, their employees, they can give that broad form today.
And you're telling me that your subs aren't all operating under MSAs?
Well, I have an MSA with that one guy because I may do several different projects under a master services over the length of our engagement. I may have him clear a line here. I may give him a clear line over in West Texas. But I'm not doing a master services where I have a series of contractors doing a myriad of different things all at one site. I'm building line and pole. So I got one guy is going to be putting up all the poles and putting up all the conductor. We have a much simpler arrangement. And again, this is the legislature saw that there was a wisdom in excluding public works for the same reasons. Taxpayers shouldn't have to ultimately take that kind of exposure when the city hires a contractor to do the work.
Okay.
And I think we're in the same place if we're building public infrastructure. Again, I'm not talking about buildings. I'm not talking about an office building for the company. I'm talking about wires, poles, conductor, and substations. That's it.
Okay, thank you. Members, any other questions?
Yeah, there's,
Senator Zaffarani? I'm sorry, Dean Zaffarani, did you have a question? No? All right.
well, I had a question.
Senator Nichols.
Fred, would you say it's, what he was saying was whenever something occurs out there and they get sued, under the current situation, whoever's got the deepest pockets is always going to be on the list of people that get sued. The whole time I was in business, no matter what happened, I get sued. I haven't been sued since I sold all my businesses. Is interesting. Would you say that that was a fair statement that he made?
I'm not a plaintiff's personal injury attorney, so, I understand the question, which is they're going to target who they think can pay. I understand that. Now, like I say,
Well, yeah,
most of the time it's going to be your employee, and so you can sign a broad form indemnity and they can tender right back to you and go to your insurance and they can stay out of the equation. But I wouldn't quibble with the idea that a personal injury attorney would want to go after the deepest pockets. I understand that.
All right, thank you.
Hope I answered your question.
Thank you. Any other questions? Thank you, panel. We have one more witness, Jennifer Fagan. Please state your name, who you represent, and whether you're
Yes.
testifying on, for, or against.
Mr. Chairman and members, I'm Jennifer Fagan, and I'm here on behalf of the Texas Construction Association. I signed up mainly because Fred only got 2 minutes. So I just wanted to add a couple of more points. House Bill 3306, which we oppose, is very broad. It's not just for vegetation management. That seems to be the core of most of the examples that we get, but it is much broader. It's essentially any construction of infrastructure, electric utility infrastructure, and for transmission and distribution lines. And I will just add that I'm sure this committee is all aware, we're about to spend $60 billion on thousands and thousands of miles of transmission lines. So we're about to increase that possible exposure for the contractors who are working on those lines. Additionally, I don't practice law traditionally, but the analogy I like to use is when you have broad form indemnity, you're having the largest amount of liability pushed down to the smallest company. So you're going all the way up from everybody's liability, from the utility to the general contractor to the subcontractor and possibly the sub, all funnels down to the guy at the bottom of the totem pole. And sometimes if it's vegetation management and it's out in West Texas, it could be a sole proprietorship. It could. You could have a guy who's just hired to go mow the lawn, and their personal assets would be at risk if they're a sole proprietorship. So I think this is a little bit bigger than maybe Mr. Seamster wanted to indicate, because for our guys, it could be, it could be a big thing if they're forced to cover somebody else's liability.
Thank you. Members, any questions? Hearing none, thank you.
Thank you.
Is there anyone else wishing to testify on, for, or against 3306? Seeing no one, public testimony is closed and the bill will remain pending, subject to the call of the chair.